Hello. In this video, we're going to discuss the essentials of an ESI protocol. Protocols typically result from a series of negotiations or meet and confers between the parties. The terms are typically dependent on the nature of the matter, the nature of the relevant information that the parties will exchange in discovery, and the particulars of the eDiscovery software being used by the parties. That said, there are 4 basic categories of agreements that should be included in a standard ESI protocol. We will discuss each of these separately. The first portion of an ESI protocol should include agreements on the scope of discovery. The proportionality provisions in the Federal Rules of Civil Procedure should serve as guidelines as the parties negotiate the provisions of their protocol. The proportionality analysis in Federal Rule of Civil Procedure 26B1 provides that discovery should be limited to information relevant to any party's claim or defense and proportional to the needs of the case, considering the amount in controversy, the party's relative access to relevant information, the party's resources, the importance of the discovery in resolving the issues, the importance of the issues at stake in the action, and whether the burden or expense of the proposed discovery outweighs its likely benefit. These proportionality factors should be top of mind when addressing the scope of discovery in an ESI protocol. The negotiations dealing with agreements on scope should include the relevant time frame for searching data, as well as agreements on relevant custodians. The higher the number of custodians, the more data is subject to search, so there are opportunities to narrow and focus discovery by managing the number of custodians whose data will be collected and searched. Parties should focus on the custodians that are most likely to have relevant information and defer or set aside custodians that have largely duplicative data or information not relevant to the issues in the case. Similarly, there may be sources of information that can be excluded from collection and searching, such as databases that contain duplicative or irrelevant information. The second category of negotiation for an ESI protocol is how the collected documents will be searched or filtered to locate the relevant information to be produced. With rapidly developing technology, the processes for searching and filtering large data collections to locate information to be produced are expanding. The parties should be transparent about what technology they are using, whether it be traditional search terms or more advanced artificial intelligence tools such as technology-assisted review, commonly called TAR, or other artificial intelligence tools. Note that perfection is not the standard under the federal rules when using any of these searching or filtering tools. The requirement is instead a good faith search. There are a large number of cases that confirm that both the use of search terms and TAR, or both in combination, are reasonable searches. While we don't yet have case law specifically approving the use of tools like generative AI for the searching and filtering process, we anticipate that we'll see those sorts of rulings in the near future. We anticipate that courts will use a similar analysis for generative AI as with TAR and require transparency and cooperation with the deployment and confirmation of those tools. The parties should reach agreement on the tools to be used, and if using TAR or other forms of AI, the parties should be transparent about the mechanisms to be used to determine the accuracy of the tools, such as statistical sampling, and include them in the protocol. The third subject area to be included in an ESI protocol is the form of production. This is perhaps the area of the protocol that is the most technical, but which should not consume a lot of counsel's time or attention. The eDiscovery vendors selected by the parties in the matter should be able to provide standard specifications for the productions they are to receive. Those specifications generally consist of whether documents will be produced in TIFF or JPEG form, which document types need to be produced natively, such as Excel and PowerPoints, and the technical aspects of extracted text for the documents and the provision of a database load file. It should include the metadata fields for certain pieces of information, such as the custodian or author. In the case of email, the to, from, the Bates number of a document, and the Bates ranges of its family members or attachments, and other technical provisions that allow for fast and efficient loading of opposing party productions into the database, as well as facilitating review of the incoming productions by the counsel team. Ask your vendor for their production specifications and include them in the protocol to ensure that opposing party productions can be loaded quickly with a minimum of time and cost. Be sure to share the party's requested form of production with your eDiscovery vendor prior to production to make certain that the productions meet your opposing party's criteria. The fourth major category for discussion in the ESI protocol is the process for dealing with inadvertently produced privileged documents. Given the current volumes of electronically stored information collected and reviewed, no matter how carefully the parties plan and execute their document review strategy, the likelihood exists that privileged documents may accidentally slip into the production. Federal Rule of Evidence 502B was enacted to protect parties from a broad subject matter waiver due to the inadvertent disclosure of privileged documents, and Federal Rule of Evidence 502D protects the party who has inadvertently disclosed privileged documents from being forced to produce those documents in another proceeding if the parties have executed an order under 502D that is signed by the court. The parties should agree to enter into a 502D order and have it signed by the judge to protect their client from the dangers that can result from the inadvertent production of privileged documents. No need to wait until it happens to have those conversations and reach agreement. These are the four main categories of negotiation: scope, searching and filtering, form of production, and privilege clawback. While there can be a number of other potential areas of negotiation, these four areas constitute the majority of the terms included in an ESI protocol. Our team of experts at the Discovery Experts is happy to discuss ESI protocols in more detail with you. Contact your consultant if you have any questions, and be sure to check out our other videos.